And what did you do to look at the web usage on the phone, and what time frame did you look at?
For web usage, I expanded the time of interest to early January to the 24th of January, and just took a look at any web history over that time. There was over 1,300 records recovered. I took a cursory look down that list and highlighted some which potentially were relevant to the case, and then provided the 1,300 actual records as a appendix report.
And going to page 12 of your report, looks like you started here on January 10th, 2023, is that correct?
That's correct.
And basically here you list various searches that occurred on each day between January 10th and January 24th from the extraction, is that correct?
That's correct. Broken down by day with the time of the search, the website that was visited, the title of the web page, and then the identifier in the database.
And looking at these searches, on January 12th, 2023, at 19:48, so that would be 7:48 p.m., is that correct?
Correct.
There was a search. In the title it says, "How quickly does Wellbutrin work for depression?" Is that the title? Is that what the user is putting into the search?
If I could see the search, please.
I'll zoom in on that.
Yes, so the top entry here we can see starts with https www.google.com/search $Q. The text after the Q, how quickly does Wellbutrin work, is what the user searched. Typically that is exactly as the user typed it, assuming that there are no auto-completions in place. In this particular case, it appears it was searched using Safari, so there's no auto-completion. That is essentially what the user typed in. And then the title, how quickly does Wellbutrin, I can't say that word, I'm afraid. Wellbutrin, thank you. Work for depression, Google search, is the title of the page which Google assigns.
So where it says after the Q, how plus, quickly plus, does plus, the user's not putting in those pluses, correct? Is that, what were you calling those?
So that's part of the attribute. It's how the data is encoded in a URL or in a web search. You can't have spaces within this address string, so they replace the spaces with the plus symbol.
So I type in how quickly does, and the computer adds the pluses in the space marks?
Yes, it's URL encoding to make it safe for the browser.
And then at 7:49, there's a search for Lamictal for depression.
Yes, and depression spelled with a B at the end instead of an N, which demonstrates that this is what the user typed in rather than a page that was being visited.
And then a few minutes later at 7:55 p.m., the user typed in Elavil for depression, correct?
Correct.
And then on page 16, on January 18th, 2023, at 10:25, we have a search there, ketamine for suicidal ideation, is that correct?
Correct.
And again, that's the user typing that in?
Yeah, again, those words were typed in by the user.
then on January 19th, 2023, on page 17 of your report, we have symptoms of postpartum psychosis searched on January 19th.
Correct.
And again, so we're looking at, this is AM, correct? 9:24 AM that was searched?
Yes, the morning.
And then 9:30 AM, there's another search for psychosis symptoms?
Yes.
Going back to that same page, page 17, at the bottom for January 24th, we have here searches for kids Miralax at 4:02 p.m. and takeout 3V at 4:13 p.m. Is that correct?
That's correct.
And then CVS Pharmacy at 4:47 p.m. Correct?
Correct.
There was also an Apple note that you found in the records, correct?
That was.
The Apple note, in your report, it says it was created on December 22nd, 2022 at 10:23 a.m. Strike that. And then modified at 10:23 a.m. on January 23rd, 2023, correct?
Correct.
And are you able to tell what in the note was modified?
No, there's no real auditable log to look back and see how many times it's been modified over the course of its life. I was able to do some amount of recovery to see that on the day it was created, it started in a very similar way to as it's written on the 24th or 23rd of January, but the exact changes between when it first was created and the last time it was modified, we don't know.
And then you also looked at messages, correct?
Correct.
And were you able to compile the messages that were sent and received between the defendant and her mother and the defendant and her husband on January 24th, 2023?
I did, yes.
And were you able to arrange it using the tools that you use in a way that looks like you might see it on your phone?
Yeah, I tried to prepare it in a report which would be easy for any viewer to understand based on their own usage of text messaging.
So showing you page 19 of your report, what we have here is an enlarged version of what you might see on your phone, correct?
Correct.
And so is this in blue, is this Lindsay's phone?
It is. The messages in blue on the right would be outgoing. The messages in grey on the left would be incoming.
And so we have a photo being sent out from Lindsay's phone to her mother, and then a reply coming back, and that pattern goes on and on, correct?
Correct.
And then looking at page 22, you were able to do the same in terms of her contact with Patrick Clancy that day, correct?
I did, yes.
And so in gray, we have Patrick Clancy sending a message to Lindsay Clancy, and in blue is the response, correct?
Correct.
Were you, were you also able to look at the phone calls that occurred either incoming or outgoing to the defendant's phone on January 24th, 2023?
I did, yes.
And And looking at page 27 and 28 of your report, first on page 27, just looking closely at the phone. Here in the report, it says 2024. Is that a typo? Is that supposed to be 2023?
That's meant to be 2023, yes, I apologise.
Okay. And so what we see here, can you just tell us what these columns are?
Yeah, the start time of the call, typically when it is answered by the recipient. The end time, when the call's ended. The metadata is information including who the call was to or from, how long the call lasted, and then the reason that the call disconnected, and then a record ID. So if you had the database, you could go in and find this record based on the ID number.
And looking at page 28, this is the continuation of that table regarding the phone calls, is that correct?
Correct.
And so what we're seeing here is at 17:33, which would be 5:33 p.m., there's an incoming call from Patrick to Lindsay's phone, is that correct?
Correct.
And it says duration 8 seconds, 0 seconds. Does that mean it was not answered?
In this case, it was an unanswered call.
And then at 5:34 p.m., roughly a minute later, there's an outgoing call from Lindsay's phone to Patrick's, correct?
Correct.
And that call was approximately 14 seconds?
Correct.
And then at 6:09 p.m., another incoming call from Patrick to Lindsay that went unanswered?
That's correct.
Now, you also, in a section you call media, you have some photographs that were taken from the phone with some metadata included, correct?
Correct.
What is metadata?
Metadata is information about that photograph. It could be the device that captured it, the time that it was captured, the location, information about the lens, the lighting, etc.
And so looking at page 29 of your report, just for an example, what we have here are 3 photographs, correct?
Correct.
And the metadata for the first one shows captured at South Shore Medical Center, is that correct?
Correct.
How were you able to determine that's where that photograph was taken?
The metadata of the photo included the latitude and longitude where the image was captured. I took that latitude and longitude and looked on Google Maps to see a physical address. In this case, it came down to the South Shore Medical Center.
And then the third photo here, that shows captured at the home address on Summer Street, is that correct?
Correct.
And then you looked at device usage. What is device usage?
Device usage would relate to how the user is operating the device. So when they have it unlocked, locked, what applications being used at any particular time. Essentially anything which is not a message or a phone call or results in additional data like that.
And looking at page 32 of your report, in that device usage log, it shows that the last time the device usage was logged was at 5:13 p.m., correct?
So this table relates just to the locking and the unlocking of the device. So the last time the device was unlocked was at 17:13:16. The device was locked again around 2 minutes later at 17:15:12, and the device was not unlocked again.
And so where the device was not unlocked again after 5:16 p.m., but we have a phone call being made at 5:34 p.m., how does that happen?
There is a setting within iPhones that allow you to use a locked device to call back numbers for missed calls. So in this case, Lindsay had the missed phone call that would have shown on screen as a notification as a missed call, and without unlocking the device, you're able to call that person back.
So you just press on the icon that shows up, you have a missed call, you press on that, and you can call the person back without unlocking the phone?
Correct.
And then what is application focus?
Application focus is literally the application which is visible on screen at any given time.
And at 4:13 p.m., 16:13, on January 24th, you've highlighted it in green here. What are we seeing there?
At 16:13:23 until 16:14:50, the Apple Maps application was being used, visible on screen.
Is it then used again at 5:13 and 5:14 p.m.? Or is that a different application?
So at 5:13 until 5:14, it was mobile Safari, so the mobile version of Safari, the internet browser, was on screen, and at 17:14:47 until 17:15:08, it was the mobile SMS or messaging application, which was on screen.
So do you just look at the part that's in parentheses to see what application was open or being used at the time?
Correct. What application was on screen at the time?
So for example, where it says 17:34, which would be 5:34 p.m., and in parentheses is in-call service, does that represent a phone call?
It does. That's the screen that indicates you're in a phone call.
And staying with the same page, page 34, you've made some notes here. Let's go out a little bit. Regarding Apple Maps, Safari, and messaging. So can you just explain what you pulled from the data for Apple Maps?
Yeah, Apple Maps was used to plan a route from the user's current location, the home address, to a restaurant called 3V.
And that was at 4:13 p.m.?
It was.
And then in terms of Safari, you have the last unlock at 5:13 p.m.?
Yes, so the last unlock of the device was used for the purposes of viewing Safari, where PDLX was searched using Google.
And then in terms of messaging, what did you pull from the data there?
At the same time, or in that same device usage, so the device was unlocked, Safari was used to search PDLX, and then the messaging application was opened to send a message to Patrick saying PDLX liquid stool softener.
And that was at 5:15 p.m.?
It was.
And then did you create a timeline combining all the data that we've talked about into one timeline?
I did, yes.
I'm going to the last page of your report, page 43. Is this the last page of the timeline?
It is, yes.
And in that page, can you explain what we're seeing here?
Yes, so the very first column is the timestamp. The next few columns, which show typically coloured, is related to the activity, which will become a little bit clearer in a moment. The row or the column in the centre explains what the record is. So if, for example, we look at the 17:13:16 record, we can see a U, which means the device was unlocked in pink. That unlock event lasted until 17:15:12. So hence that entire column is in pink and shows the relevant lock event.
So here we have 5:13 device unlock.
Yes.
5:15 device lock, and there's this column connecting them, correct?
Correct. And then any activity that happened during that unlock time is then shown within the rows between. So again, we see Safari open at 17:13:16. Safari was closed at 17:14:47. Messaging was opened at 17:14:47. While messages were open, there was an outgoing message sent for PDLX. Then messaging was closed. Messaging was opened again, and messaging was closed prior to the device locking. So everything in the coloured columns tries to show all of the events that happened at the same time or during that parent event.
And what we have here at 5:33 p.m., we have the flight climb started, is that correct?
Correct.
And flight climb ended at 5:38, so
Yes.
that line again connecting them?
Correct. So 2 flight climbs occurred during that time period.
And in between when the flight climb started and the flight climb ended, you have the 2 calls, the incoming call that was missed from Patrick and then the outgoing call to Patrick, correct?
Correct.
So the first flight climbed had already been started. Someone had already started climbing up a flight of stairs when that first unanswered call happened, correct?
So flight climb started is how it's listed within the database and within the software. But it actually, the flight climb time is when the flight climb has been recognized by the device as the device has already climbed up those stairs. So even though it says flight climb started, that's technically the time that the flight climb or the first flight climb had ended.
So where it says 5:33:34 flight climb started, that actually indicates the person has gone up that first flight of stairs already.
Yes, that indicates the phone has now realized I'm 3 meters higher than I was the last time I checked. Therefore, a flight climb has already been completed at that point.
And then the calls happen, and then the phone realizes at 5:38 that another flight has been climbed.
Correct.
I would move to submit the report as the next exhibit.
No objection.
All right, that report may be admitted.
Is it 266?
I have nothing further.
All right. All right, so members of the jury, remember I said it might be a little stop and start here today. This is one of those stops. All right, so we're going to take a short break, and then we'll come right back and return for the cross-examination of this witness. Okay?
All rise, please, Your Excellency.
Jurors have exited the quorum. Court's in session.
All right, so the court will be in a short recess at this time. Thanks.
Court, all rise. This court is back in session. You may be seated.
Yeah. Counsel, we ready for the jury?
Yes.
All right. Yeah.
All rise, please, Jurors entering.
may be seated.
Your Honor, for the purpose of the record, you return back to the call, Commonwealth versus Lindsay Clancy, all parties present, including 18 jurors.
All right, thank you, Madam Clerk. Mr. Reddington?
Thank you, Your Honor. Morning.
Good morning.
Mr. Whiffen, just a couple of things. One of the takeaways or question that I had is that you were talking about, in reference to the Apple Health data, it's fair to say that there's an issue as to the accuracy or reliability of the Apple Health data. You've actually done research on that.
I've done research on it, yes.
Okay, and one of the things that you did is back about a year ago, June 28th of 2025, you did a blog article on Apple Health accuracy and reliability, and it talked about using a pitch, which I think is, you guys refer to like a football field?
It was a rugby field, but yes.
And then you had somebody put the watch in their right pocket, somebody with the left pocket, and then someone else held it in their hand, you measured it, and things of that nature, right?
Correct, it was 3 phones.
Some of the things were off a little bit, but basically you put that in your report and you were able to draw your conclusion as to the accuracy and reliability, as you say, of the Apple Health data, right?
Correct.
Now, if someone is wearing an Apple Watch, is that what records heart rate?
As the heart rate is on the watch, yes.
It is on the watch,
Yes.
okay. And the steps that the person takes, things of that nature, the movement, is that on the phone or would that be on the watch?
That's on both the watch and the phone.
Okay. Now, if you have an Apple Watch and you test it or you examine it, would you be able to determine what information was actually recorded by the watch while the person was wearing it?
Yes, the information that's recorded within the Apple Health database does specify whether the information comes from the watch, the phone, or from a different device.
Okay. And in this case, if I understand correctly, the Apple Watch stopped recording data at, is it 5:23?
It was around that time.
Okay. You know what? I'm going to give you your report. Feel free to just refresh your memory or look at it or whatever helps you out.
Thank you.
Yep, no problem. I just want to get the times down. I think you indicated that the watch stopped recording information at 5:23 p.m.
Yes, the last heart rate was 5:23:52.
52, okay. 5:23 and 52 seconds. And then I believe the phone and watch stopped recording at 5:38, was it?
The last usage of the, let me double check this. I believe the last usage of the phone to record flight climb data was at 5:38, yes.
All right, and after 5:38, it's pretty much blackout. There's no further information or recording, right?
Yes, not until like the phone was seized by police, I believe.
By the
but
police.
There's other activity, but appeared to be after the incident.
So the further activity would have been the following morning on the 25th of January, say around 5:30, 6 o'clock in the morning?
I ended my analysis on the 24th.
Okay. Well, so 5:23 p.m., the watch stops recording information. 5:38 p.m., both the watch and the phone stopped recording any information until the police picked up the phone apparently the following day, right?
Again, there would have been activity later on, but it wasn't usage, it wasn't health data. It would have been things like incoming calls, if
Okay,
there
so
were any.
when you went through the stair climbing and talked about the steps that were taken, the distance that was taken, that stopped at 5:38 p.m., right?
Correct.
Now, you don't know, when I say you, I mean as a witness, but also the police, whoever was wearing the watch, for example, if Lindsay's wearing the watch or carrying the phone after 5:38, you don't know what was happening at 5:39.
Correct.
You don't know what was happening at 5:40, 5:45, right?
Correct.
Right up till 5:58, 6 o'clock p.m., right?
Purely the data on the device.
So it could have been, the phone could have been put down the watch could have been put down, battery died, whatever those issues could be, and the person would still be going down the stairs, going up the stairs, going in the backyard, doing push-ups, whatever.
Correct.
You just don't know, right?
Yes.
Okay. One of the things, you're familiar with the concept of location data, right?
Correct.
And location data, one of the things you looked at or you're aware of would be from Lindsay's phone on August 23rd of 2022. Is that correct?
Apologies, August 23rd, 2022?
Yeah.
I didn't go back
Okay.
anywhere near that date.
You have tested and written blogs, though, on location information, right?
Correct.
You actually testified in the case of Commonwealth versus Victor Arrington in Suffolk Superior Court in Boston in support of the accuracy of this particular artifact or information, right?
Correct.
So you're a true believer that the phone does in fact record accurately significant locations on the iPhone, right?
It certainly can, yes.
All right. And are you aware, or if I was to approach you in your expertise, it's just a doctor's. That's all. You were talking earlier about latitude, longitude, things of that nature, right?
Yes.
So just to, you're familiar with, for example, significant location visits on Lindsay's phone, August 23rd, 2022 at 9:34. Do you know what that says or what that means?
The created time
Yeah.
of 9:34. That'd be when the device decided that the device had visited this location enough to consider it a visit.
Okay. Do you know what that location is? If I suggest to you it's a doctor's office, would you be aware of that?
I don't recognize it from the coordinates.
Okay. Thank you. This here you're familiar with too as well, right? The geodata with the latitude and the longitude?
Yes.
And you're familiar with the fact that you can take the metadata off of the information on the cell phone, one of which would be latitude and longitude. You'd be able to determine, for example, that this would be the Lindsay Clancy home, correct?
Yes, correct.
You've seen this before, right?
It rings a bell, yes.
Okay. I'd offer this, Your Honor.
Any objection?
No objection.
Okay, that may be admitted.
Thank you.
Exhibit 267.
All right, thank you.
Now, you have your report in front of you, right?
Yes.
And that's captioned Digital Forensic Report, and it's in evidence, so the jurors are going to be able to review it in its entirety, right?
Yes.
If I could direct your attention to page 11, I believe. Yeah, page 11. Okay?
Yes.
And just so the jurors are able to acclimate themselves to it, that would be this item here that you went through with the district attorney, right? As far as the...
Right back to the trial. So I want to do first, ask you those questions since we had a long break, and then talk a little bit about the schedule and kind of today's schedule and kind of where we go from here. So first question, as you know, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Next question, is there any other serious matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? Again, thank you so much for following those instructions. Today's schedule is that it may be kind of a little bit stop and start. Okay, so kind of bear with us on that. Might be a couple times you got to take a break just after a short amount of time, and then we'll bring you back in. It's just the nature of cases at this point. It's anticipated that the Commonwealth will close their portion of the evidence today. All right. Then at that point, the defendant has the opportunity, if they want to present witnesses and evidence if they want to. But remember, they don't have to. The burden of proof is always on the Commonwealth. All right. If the defendant offers evidence, then the Commonwealth is then given the opportunity to offer rebuttal evidence. All right. And so that's kind of the next phase that we're about to go into after the Commonwealth rests. And I'll go into a little bit more kind of how that goes, but I just kind of wanted you to kind of see where we are and where everything's going to fit procedurally as we go forward from here. So with that, we're going to return to the Commonwealth's case. And Attorney Sprague?
Thank you, Your Honor. Commonwealth calls Ian Whiffen.
Good morning. You solemnly swear that the testimony you give that you shall give to the court and the jury between the Commonwealth and the current project.
I would rather affirm I do.
Thank you.
Thank you.
All right. Good morning, sir.
Good morning.
All right. Attorney Sprague, please.
Thank you. Good morning. Can you please state and spell your name for the record?
Yes, it's Ian Whiffen. IANWHIFFIN.
Where do you work?
Cellbrite.
What is Celebrate?
Cellbrite is a digital intelligence company working in the digital forensics field.
And how long have you worked there?
Since 2020.
What is your role at Celebrate?
I'm currently a customer engagement manager.
What does that mean?
I work with customers, helping users of our tools to understand the digital evidence that they're finding and presenting.
And what does digital evidence consist of?
Any information which is extracted from a cell phone, primarily or from a computer, which can be interpreted by the examiner and presented as evidence. It could be call history, messages, location data, media, anything that you can find from a digital device.
And could you just briefly describe your educational and training background that qualifies you to do this work?
Yeah, I've worked in IT for many years. In 2013, I began my career within Calgary Police Service in Canada as a digital forensics examiner. That was after spending approximately 9 or 10 years working as a patrol officer in the UK and in Canada. As part of my role as a digital forensics examiner within the Calgary Police, I went on numerous training courses. The Canadian Police College, they did an introductory course into digital forensics, and then further courses focusing on mobile data provided by some vendors, such as Blacklight or Cellbrite at the time, as well as further courses presented by the Canadian Police College, specifically about cell phones.
And Celebrate, the software produced by Celebrate, is that software used to extract and analyze data from cell phones and computers?
Yes, there are several tools within our catalogue. One of them is designed to extract as much data as possible from a cell phone. And then one of the other tools is designed to take that extracted data, decode it, decrypt it, make sense of it, and provide it to the user in a way which can be searched, filtered, organized, reported, and presented.
Does Celebrate's ability to access cell phone data continually change based on improvements that are done to the phones themselves?
Yes, there's constantly changes being made to devices which make it difficult to extract the data. There are changes being made to the software that means that the data that we extract is now different to the data that we extracted previously. A new feature, for example, or a change that's made by the software developer. So we're constantly changing our software to be able to extract that data and to decode more data.
Were you asked to locate Apple Health data and other information that could be relevant to the investigation of an incident that occurred at 47 Summer Street in Duxbury on January 24th, 2023?
I was, yes.
And what is Apple Health data?
Apple Health is a component of the iOS operating system, which logs sensor data from multiple locations. So there's sensors built within an iPhone that monitor steps taken, flights climbed, for example, as well as third-party devices, Apple Watches, Fitbits, any other device like that. All the information is brought into the Apple Health application, aggregated, and made available for the user to see.
Roughly how many phone extractions have you done?
Since around 2013, well over 1,000 phones.
And how many times have you done analysis on phone extractions?
The analysis is part and parcel, so of those 1,000 phones or so which I've extracted, I've done analysis on all of those phones as well.
And then you've also done analysis on extractions, like in this case where someone else did the extraction and provided the information to you and you did the analysis?
Correct, yeah. Whenever I'm helping customers or users of our tools, they may provide me with the extracted data. So the data which I'm analyzing is more than the devices I've extracted.
And have you testified previously in courts about what you've done in terms of extracting and analyzing information?
Yes, I've testified in multiple courts around the world, approximately 28 times.
Now, you received a copy of the extraction for Lindsay Clancy's iPhone 13, correct?
Correct.
And when you received that extraction, did you also want to know all the specific information about the case and the investigation?
Typically, when I'm working a case, I don't want to know a lot of detail. I'd rather come to my own conclusions based on the data that I'm viewing rather than note the intricacies of the case. All I require is an outline, the date that something happened, the time, who was involved, basic information.
And in terms of the extraction that was done on Lindsay Clancy's iPhone, that extraction, what type of extraction was it?
That's what's called a full file system extraction. It's essentially all of the data which is being extracted from the device that is still live.
And did you use specific tools to conduct your analysis?
Yes, there's the Cellbrite physical analyzer tool created by Cellbrite and also my own tooling. Applications that I've been working on for several years.
So you've actually made your own tools that allow you to examine phone extractions?
Correct. There's some tools that I've been working on since prior to joining Cellbrite. Tools that as an examiner I decided that I needed to create for myself and make available to others. And I still use those tools to this day.
And these tools that you used, are those the tools that allow you to examine and categorize the information, the data that you find in the extraction?
Yes, the primary point of the tool is to go into the data, decode it, provide it in a way which is easy to filter and search, but also additional tools there that allow you to dig into the data and look at the raw information, the databases, the files, all of the raw information, which is what our tools initially decode.
And did you focus in on a particular time frame when looking at the data on the defendant's iPhone?
Primarily, I knew that the date of the incident was 24th of January 2023, so that was the main focus of my analysis. But some of the data I was aware could be from further afield than that, so I took a look of, I think it was around 3 weeks before that, so early January to late January.
Were you able to look at the health data on January 24th, 2023 that was in the defendant's phone extraction?
I was, yes.
And what is health data? And how does it show up on a phone?
The user of the phone would be able to access the health data via the health application, where the information is broken down to explain how many steps have been taken over a particular period of time, the approximate distance that was travelled, the number of stair flights that were climbed. That data is stored on the device itself in a database. So as a forensic examiner, I can take a look at that database in its raw form and understand exactly where that information is coming from and present it to the user of our forensic tools in a slightly more forensic-friendly method than the user of the application on the phone would see.
Showing you on the screen here, page 4 of your report. Looking here, we have a section here, heart rate data, is that correct?
Correct.
And you're able to see here, what can you tell about the heart rate data from the extraction?
So heart rate data comes from wearing an Apple Watch or a similar device, not from the phone itself. In the case of this phone, there was an Apple Watch paired to the device, and all of the heart rate data, which is recorded periodically throughout the day, is stored within the health database.
And what was the name associated with the Apple Watch?
So as it says in the third paragraph down, the Apple Watch itself was called Lindsay's Apple Watch.
And here in the report, you're able to show the recorded heart rates throughout the day. How is the heart rate recorded and sent to the phone?
There are sensors on the Apple Watch itself on the rear, which periodically check the heart rate at any given time, and that information is sent to the phone via Bluetooth.
And are you aware of how often an iWatch will record the data and report it to an iPhone?
The actual cadence at which the watch is checking would depend on what the user's doing. So if you were in the middle of a workout, it would be a lot more consistent than just periodically throughout the day. And I actually don't know how often it is throughout the day. If you're not doing any particular workout, there doesn't seem to be a set cadence. Every device I've looked at, it's slightly different.
I'm showing you page 5 of your report, this database of the heart rates. For example, in several locations, there'll be a heart rate report, maybe a few seconds in between them, and others there's 7 or 8 minutes in between the heart rate report. Is that what you're talking about, how it varies depending on what you're doing at that point in time?
Yes, this is typical from what you see when you look at the database. The timestamps are never consistently at a recognizable cadence.
And the highlights in green, what do those represent?
So I actually tried to just highlight some of the high points for the day. I realized a few days ago while reviewing this, there was records there that show a high of 123 and 122, which I had not highlighted.
And that's right there, right below, right
Correct.
around 1146.
Yes.
And what was the last time a heart rate was reported from the watch to the defendant's phone?
So the last heart rate recorded was at 17:23:52, so 23 minutes past 5 in the afternoon, with a heart rate of 57 beats per minute.
What was the average heart rate for the day for the defendant's phone?
There was a range of heart rates going between as low as I believe around 50 and as high as around 122. On average, it was around high 80s, early 90s.
And so at 5:23 p.m., the last recording of her heart rate was 57?
Correct.
And there aren't any further heart rates reported to the phone after that point, correct?
That's correct.
And what are some of the reasons why a watch would no longer be reporting a heart rate to the phone?
If the watch was taken off, if the watch was turned off.
If the battery died?
The battery was dead, yes.
Okay. You also mentioned flight climb data. What is that?
Flight climb is information which the Apple Health application stores every time it detects that you walk up a flight of stairs. So a flight of stairs would be considered either a 3-meter or 10-foot incline at over 16 steps. So the device has detected that both the altitude has changed by 10 feet and there were steps being walked at the same time.
So there's two factors being considered there, the steps that your watch monitors as you walk, and then the altitude, is that correct?
That's correct.
And what is it? Is it GPS or something that's keeping track of your altitude?
The altitude is being monitored by a barometer or an altimeter, which is inside the device, just measuring for differences in air pressure.
And this information, the flight climb data, can that be monitored by both a watch and your phone if you have it on you?
It is. Both devices have got the barometers built in. Both devices can monitor flight climb events.
Can anything simulate or kind of fake out the watch or the phone into thinking that a flight of stairs is being climbed when it's not?
There are some circumstances where that can happen. They're typically quite rare, but it can happen.
Is an example of that being in a car and going up a hill?
Correct, yes. If there is movement which the device can mistake for steps at the same time as the incline is being driven, then that could accidentally record a flight climb.
But if a person's not in a car and is in their home, then it would be flights climbed, not hills being driven, correct?
Correct. If the person is in a house and there are flight climbs being recorded, then the only rational explanation is that the person was climbing stairs.
How is the data in terms of flight climb data, how is that data displayed? Or in the health data itself?
Within the application or within the forensic tool?
Within the forensic tool.
Okay. So within the forensic tool, we break down, or within Physical Analyzer, we break down the health data into hour segments. So for an hour, we may say that there are 3 flight climbs. And then it's up to the user to dig in a little further. They can select that 1 hour and then see how that activity breaks down over the hour. So you would see that there were 2 flight climbs that occurred at 10 minutes after the hour, and then another flight climb occurred later on.
So showing you page 6 of your report here. The top box here, is that showing the general hour data where 3 flights have been climbed?
Correct. So in this case, the user is looking at a time period between 10 a.m. and 11 a.m. And the health data that's been pulled from the database has been aggregated. And it tells you that there's 98 samples being considered. The maximum heart rate during that hour-long period was 108. The distance traveled was approximately 759 meters. And there were 5 flights climbed within that hour.
And then below that, you break that down a little further, correct?
Correct. So this is further down the screen in the interface, where we can see an actual time of 10:17:27, where there's 2 flights climbed. And again, another record at 10:17:28, where there were 2 flights climbed, and then a further flight climb at 10:49.
And then going down to the bottom here, this table, what are we seeing here in this table?
So you may have realized in the slide above where there was 2 flight climbs at 17 seconds past and 2 flight climbs at 18 seconds past. That's an unrealistic measurement. It's because one of those measurements comes from the phone and one comes from the watch. This table breaks it down to say which of these records came from the watch and which came from the phone, because there are some which overlap.
So what you're saying is the prior table, it showed the 4 flights of stairs being climbed at the same time within seconds, which isn't rational. But this breaks it down to show some of that data is coming from the watch and some of it's coming from the phone, correct?
Correct. So if we look at records 4 and 5 here, for example, we can see a start time of 10:17:27 and an end time of 10:27:06, where the watch recorded 2 flight climbs. And then 1 second later, a start time, and 2 seconds later for the end time, we see the watch also detected 2 flight climbs. This is just the same 2 flight climb events that happened, but both devices recorded those flight climbs with slightly different timestamps.
And that will happen if I'm wearing my watch and I have my phone in my pocket and I go up the stairs?
That's correct.
Did you do something to compare these times and make a table where where you ignored or disregarded the double entries?
I did. I tried to correlate and discard all of the duplicate information. So where there was an event of a flight climb that was recorded on the watch and the phone, rather than provide information that said there was 2 flight climbs, I would ignore one of them and limit it to just the ones which we could prove happened.
And that's displayed here in this chart at the bottom of page 7 of your report?
Correct.
Going to page 8 of your report, we have here at the top of page 8, does that show the last flight climbs recorded on either the defendant's phone or watch?
It does. It shows that there was additional flight climb events logged by the phone, which were not logged by the watch, at 17:03 and 17:33.
So these records indicate that at 5:03 p.m., the defendant's iPhone was with the person as it went up the stairs, and then at 5:33 p.m., the iPhone was with the person as it went up the 2 flights of stairs.
Correct.
And there's a time difference there. The start time is 5:33 p.m. and the end time is 5:38 p.m. For 2 flights of stairs. So that's roughly 5 minutes in between the 2 flights. Is there a way to explain that length of time?
The way the Apple Health data records this information, aggregates it, it tries to group events together. So in this case, it would have recognized that there was a flight climb on the phone at around 17:33:34 and a second one at around 17:38:33, and it just grouped them both into one event. It doesn't mean that it took 5 minutes to walk up 2 flights of stairs. It's just within that 5-minute period, there were 2 flight climbs.
So if I have my phone in my pocket and I climb up a flight of stairs and then I spend a few minutes on that floor and then still with my phone in my pocket go up another flight of stairs, that's representative of what we're seeing here at 5:33?
Correct. There tends to be around a 10-minute window where it tries to check every 10 minutes, but it can reduce that window in a case like this where it sees that there's group data within a smaller time period.
And then further down on page 8, we have another table here, which seems to have combined data of heart rate and flight climb data. Is that correct?
Correct.
Did you also look at web usage on the extraction of the defendant's phone?
I did, yes.
And what did you do to look at the web usage on the phone, and what time frame did you look at?
For web usage, I expanded the time of interest to early January to the 24th of January, and just took a look at any web history over that time. There was over 1,300 records recovered. I took a cursory look down that list and highlighted some which potentially were relevant to the case, and then provided the 1,300 actual records as a appendix report.
And going to page 12 of your report, looks like you started here on January 10th, 2023, is that correct?
That's correct.
And basically here you list various searches that occurred on each day between January 10th and January 24th from the extraction, is that correct?
That's correct. Broken down by day with the time of the search, the website that was visited, the title of the web page, and then the identifier in the database.
And looking at these searches, on January 12th, 2023, at 19:48, so that would be 7:48 p.m., is that correct?
Correct.
There was a search. In the title it says, "How quickly does Wellbutrin work for depression?" Is that the title? Is that what the user is putting into the search?
If I could see the...
Hey, all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, with him before the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court is now in session. Please be seated.
Yes.
Before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Hutchins.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? All right, again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right? And that is, as I talked to you yesterday about an issue that has nothing to do with any of the attorneys in this case. All right? It's just something we're going to work out, and I anticipate it will be worked out so that tomorrow you should count on a lengthier day. All right? I've talked to counsel earlier this morning in regards to where we are in regards to the schedule and the timeline. We are still, if not on schedule, still ahead of schedule. All right? And this delay that we may have a little bit this afternoon won't affect that. All right? So I just kind of wanted to let you know that I appreciate it. I know you came in here this morning. It's going to be a short day, but also gear up for a longer day tomorrow. Okay? And so with that, the other thing is, I told you it's got nothing to do with any of the attorneys, but it's also or the parties. So you're not to speculate about what this might be. It's also you're not to hold it against either of the parties in regards to this. All right. If you're going to hold it against anybody, you can hold it against me. All right. So with that, we're going to return now to the evidence in this case. And Attorney Reddington.
Thank you. Sheila Kavanaugh, please.
Good morning. Just face Madam Clerk, raise your right hand, please.
the testimony of the evidence you shall give to the court and the jury that the matter coming between the Commonwealth and the defense with the whole truth and nothing but the truth. Yes. Thank you. You may have a seat.
All right, well, good morning.
Good morning, Your Honor.
All right, I just ask you to speak into that microphone and keep your voice up so the jury can hear you. Attorney Reddington.
Thank you. Good morning. Can you tell us your name and spell your last name, please?
My name is Sheila Kavanaugh, Cavanaughh.
And what town do you live in?
I live in the town of Belmont, Massachusetts.
And what are you doing for work now?
I am a board-certified chaplain at Brigham and Women's Hospital in Boston.
And I didn't know that there were board-certified chaplains. What does that mean?
Well, to become board-certified, you need minimally a master's degree in theology or divinity. You need to complete 1,600 hours of training post your master's degree. 1,200 of those hours are occur in a clinical setting, and 400 of those hours are in a classroom setting where we study various disciplines: psychology, sociology, philosophy, theology, and ethics. Beyond that training, we need to acquire 2,000 hours of additional clinical training before we can even apply for board certification. And we have to demonstrate mastery of 30 competencies before we go to a national board, and they make the assessment. I also need an ecclesiastical endorsement, and in my case, that was from the Archdiocese of Boston, from Cardinal Sean O'Malley.
And before you obtained the board certification in your education to allow you to be a chaplain, what did you do for work?
Prior to becoming a chaplain, which is a second career for me, I was a senior vice president at Fidelity Investments in Boston.
And how long were you senior VP at Fidelity?
16 years.
And are you married?
I am.
You have a family?
I do. My husband and I are the parents of 4 adopted children. When I was pursuing my master's degree at Boston College, it was a 3-year master's, but it took me 5 years because we adopted our 4th child while I was in graduate school. She was a 14-year-old girl from Bogota, Colombia.
And how long have you been working now as a chaplain at Brigham and Women's Hospital?
7 years.
In the course of your duties as a chaplain at Brigham and Women's Hospital, did circumstances bring you in contact with Lindsay Clancy?
Yes, they did.
Can you tell the jurors what happened?
I arrived on the morning of Wednesday, January 25th, 2023. I arrived at approximately 8:30 that morning because I was there to relieve the overnight chaplain who was carrying the pager. I was taking over the pager shift, which went from 9 to 1 p.m., although I was working a full day. When I arrived that morning, she said to me, "Did you hear the news?" And
So sustain.
So you can't, you got to object, so you can't say what someone told you, okay? That's called hearsay?
Okay.
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 So I can say, as a result of the conversation with that person, what happened?
I was summoned to the director of spiritual care's office.
Did you have a conversation with her?
I did.
All right. And as a result of that conversation, what did you do?
I went to Unit 8C in the Tower building of Brigham to meet with Lindsay Clancy.
And what time of day was this?
Roughly between 8:30 and 9:30 that morning.
And when you went in to see Lindsay, what did you observe?
Well, the unit itself was filled with law enforcement officers, both outside the doors of the unit. There was Brigham security, but the unit itself was flooded. There were people from Plymouth County, Boston City Police, Brigham Security, so I had to make my way through concentric circles of law enforcement to even get to the room. I was permitted to see Lindsay, although she could not speak at that time.
And what was her condition that you observed?
She was dressed in medical armor. She had tubes. She was intubated. She had bandages. She had a neck brace. She was just covered and layered in equipment that enabled her to breathe.
Now, I'm showing you Exhibit 121 and asking, this may be South Shore, or it could be Brigham and Women's, but is this indicative of what she appeared to be when you first saw her?
That looks like it's from South Shore because when,
Sure.
yes,
Did she have the same,
similar,
very similar?
very similar.
Like that?
Yes, very similar.
Did you see her again on another date?
I did. I saw her the next day. Again, she could not speak. She was intubated as well. That was the first week that she was hospitalized.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed, she was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday, the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two, okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe."
Was there any other conversation that you had with her?
I replied theologically to Lindsay, and I said, "Lindsay, your children are safe. They're safe in heaven with God." And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice, and the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things, you know?
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
And do you know when that was?
That was roughly late February, perhaps around the 23rd.
And did you continue to see Lindsay at Spalding Rehab?
I did.
Do you know when she left Spalding Rehab?
In the late March, early April time frame, perhaps.
Okay. Now, Brigham and Women's Hospital and Spalding Rehab are under the same umbrella of hospitals, is that right?
They are. So Brigham and Women's Hospital and Spalding Rehab are under the Mass General Brigham complex. So for me to visit Lindsay in Spalding, I was still within the same hospital complex, and her psychiatrist at Spalding, as well as the chaplains, advised me to continue.
You can't say what anybody told me.
Oh, sorry.
So When she was discharged from Spalding Rehab, where did she go?
She went to Tewksbury State Hospital.
And fair to say that that would be back around February. It's been a little more than 3 years, or 3.5 years.
Yes.
Is that correct? Now, when you saw her in Spalding Rehab and in Brigham and Women's, you were acting in the course of your job. Is that right?
That's correct.
You're being compensated, you're getting your paycheck and that type of thing. Right?
Yes.
How many times have you seen Lindsay at Tewksbury Hospital?
Perhaps 200 times.
Tell the jury why you continue to see her for 200.
Sustained.
So, can you tell us how often on a weekly basis you would see her at Tewksbury?
Yes. When Lindsay was admitted to Tewksbury State Hospital, I continued to see her on a weekly basis. We had built up a very comfortable, respectful rapport, and I felt it was in her best interest to continue that as she healed. She was still in deep grief. She was suffering.
Sustained.
So,
That opinion will be stricken.
so did she express anything about her children and their loss over that period of 200 times that you saw her thereabouts in Tewksbury?
Objection.
No, overruled.
Yes.
Other jurors?
Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
Objection.
Overruled. Next question.
And has that continued to your observation?
It continues presently.
When was the last time that you saw Lindsay in Tewksbury?
Just prior to the trial starting.
Thank you very much. Appreciate it.
Thank you.
All right, Kamal?
Thank you. Excuse me. Good morning.
Good morning.
You were talking about on January 25th, 2023, when you first saw Lindsay in direct examination, and you said that there were a lot of police officers in the area, correct?
Correct.
But you mentioned that some of them were security personnel from the hospital, correct?
Correct.
And you're aware that the security personnel for the hospital don't work for the state police, the Duxbury Police, or the Plymouth County DA's office, correct?
Correct.
So they're separate and apart from law enforcement, correct?
Yes.
And then are you also aware that on January 25th, 2023, there was a search warrant being executed to collect evidence from the defendant and from the belongings that she had at the hospital?
No, I was not aware of that.
Were you aware that that collection of the search warrant required state police and personnel from the crime lab to be present for the collection of evidence?
I was not aware of that.
Were you aware that following that, at any given time, there were only 2 officers, either Duxbury Police, State Police, or Plymouth County Sheriffs, at her room, the defendant's room, at any given time?
I do recall that.
And they were stationed outside of her room, correct, in the hallway?
Yes.
So that the only time you saw this large amount of officers present was on the 25th, when there were security from the hospital and search warrants being executed, correct?
Perhaps.
Now, you mentioned that on January 31st, 2023, you spoke to the defendant, and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events. Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And speaking of Spalding, you continued to visit her at Spalding, correct?
Yes.
In those conversations with her at Spalding, did she tell you that how in those first weeks at Spalding, that part of her physical therapy, she was working out with a yellow exercise band? No?
I don't recall her telling me that.
Did she tell you that during that time at Spalding, she reached out to a social worker there and asked for help filling out SSDI paperwork to get an income?
That would be beyond the scope of our conversation.
She didn't tell you those things?
No.
Thank you.
So, counsel has asked you about her filling out a form for SSDI. Were you aware of what expenses her family were incurring as a result of her physical incapacity, paralysis, and being in the hospital?
From my experience with thousands of patients, I had a very clear idea of the enormous expense.
There's a difference between, as the district attorney very appropriately referred to, that your comments were about her thoughts and her appearance and her feelings. Is that correct?
Correct.
There's a difference, however, between privileged communications with a chaplain and observations of a person's feelings and thoughts, correct?
Correct.
Tell the jury what effect privileged communication has when someone talks to you personally as a chaplain.
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted, I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, I feel uplifted, or is that your
was my
observation?
perception of Lindsay. It was not her words.
Thank you.
Thank you.
Como?
You said you're not allowed to put the defendant's words in your medical records, is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes,
Thank
yes,
you.
I use my best judgment.
Okay. I would move to have these submitted as the next exhibit, the notes of the witness in her interactions with Ms. Clancy at the Brigham and Women's.
Any objection? No. All right. They may be admitted.
I have no further questions. Sorry.
Hey, Mr. Reddington, go ahead.
I have no further questions. Thank you. Mr.
Okay, thank you.
All right, thank you. You may step down. All right, counsel, can I see it? All right. I told you it was going to be a short day for you, right? And I appreciate your patience with us. So I'm going to excuse you till tomorrow at 9, all right? Same instructions. And that includes reading anything, talking about this case, watching anything. Just don't do it, all right? And when you leave here today, just drive, go home, wherever you're going to go, and plan on being back here tomorrow morning at 9 o'clock. The plan would be that it will be it will be a longer day than today. I appreciate you coming in here today. We moved the case a little bit today, and I appreciate that. So we were able to do that. So I hope everybody has a nice afternoon and evening. And we'll see you tomorrow morning for a longer day. And just remember those instructions from the moment you leave to the moment you come here tomorrow. Okay? Again, thank you so much.
All rise, please. Your executive.
Courtroom is closed in session. Please be seated.
All right. So what we'll do is we'll take a short break at this point. We'll come back. We'll do kind of a preliminary charge conference. We're going to just, which I know counsel knows, but for everybody else, discuss possible jury instructions, suggestions from counsel. Then we can talk about any logistical issues that we have for tomorrow, and then we'll probably recess at that point. All right, so this will be a short recess, and we'll come back up. Thank you.
Court, all rise. This court is back in session. You may be seated.
For the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, excluding the 18 jurors.
All right. All right, counsel, what I kind of wanted to do is at least have a preliminary discussion regarding instructions. And what I would generally do is after we have the discussion is then kind of distribute a draft to counsel so we could have a more focused charge conference next day or so. But I just kind of wanted to get everybody's thoughts or kind of suggestions that they would be seeking the court to instruct the jury on. So kind of what I'll be using will be the model jury instructions, generally the model jury instructions from the March 2026, the latest suggestions from the SJC. And so Commonwealth, let me kind of hear what your thoughts are, and then I'll hear from the defendant.
So for individual instructions, we have listed opinion testimony, prior inconsistent and prior consistent statements, redactions. I don't think there are too many, but there were some on the death certificates. Stipulations and consciousness of guilt instruction. In terms of what we're looking for for the charges, we'd be looking for an instruction on first and second, with the theories of first being both deliberate premeditation and extreme atrocity and cruelty. In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given, because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from, and I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children. And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
Let me ask you this. I'm going to ask the defendant as well, because I did read through those, and I was trying to find the definition of intoxication as it applies in the homicide instructions. Most of the cases that I was able to find so far is the dealing with the OUI statute, Chapter 90, and trying to find the real definition in regards to that. Is it the Commonwealth's position that the intoxication is beyond what was the considered effect of the drugs? Because if you know what I'm saying, so if she takes, if a defendant, I don't mean to personalize it, if a defendant takes prescription drugs and it does create some effect, would that be considered intoxicated for the instruction?
I don't believe so. I think in the instructions it talks about having being intoxicated to the point where it affects your state of mind or ability to control yourself. I think intoxication, especially where there's not a specific definition given in the homicide instructions, I think you go to the general definition of intoxication, which would not just be taking medication as prescribed, but it would be over taking medication or combining with alcohol or other drugs. It's similar to the instructions in OUIs, operating under the influence of alcohol or drugs. I think you would have to go to that definition or to the general definition of intoxication if it's not specifically defined in the instructions. And I think the general definition of intoxication is taking some type of substance, either alcohol, drugs, medication, in excess and to the point where it's affecting your ability to think and to act and to control your behavior.
All right. All right. Anything? So I've got opinion, prior, consistent, prior, inconsistent, redaction, stipulations, consciousness of guilt, first, second, extreme atrocity, deliberate premeditation, and the criminal responsibilities without the subparagraph or the paragraph regarding intoxication?
Correct.
Okay. All right. Mr. Reddington?
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge to the jury, based upon the evidence that's been presented, whether or not it's what we would argue is the over prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be, all of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence, repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos. She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams, and then subsequent to that, when there's additional SSRIs prescribed. To suggest that there's no basis to give the jury the instruction, they may determine, based on the evidence, that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention, but I have tried murder case recently with the model jury instructions, and my memory is that I was pretty satisfied. It was Judge O'Shea, I think, actually in this courtroom a year ago. And I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second, but I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice of forethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
All right. Yeah, counsel.
Thank you. Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death, so there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital, and she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital, and then she was without those medications and they're out of her system for 3 weeks, and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay, all right. All right, any other?
Yes.
Yeah, good, sure.
It just occurred to me, again, as I said, it's only fresh in my mind from a case I had here last year. I know the model jury instructions indicate, and I'm trying to find it in here, that there's supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice of forethought, etc. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice of forethought. I think you and I, we just had a murder case last year on another matter, and I mean, I heard your instructions. You're very forceful with the elements of the offense, and I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the model instructions. That's discretionary. It's not obligated. They just say that it might be helpful for the court to give the jury some type of a checklist. But I don't think we should reduce instructions on a murder case to a checklist. And I'm just afraid that what happens is that jurors then take the checklist, as it were, and they kind of look at it or consider it, and they just do exactly that. It's a checklist. So I would ask that you not do that.
All right, just so counsel, my general practice is not to have that kind of list.
Yeah, I remember
I
that, yeah.
generally don't, but I also generally will provide a copy of the instructions to each juror. So they'll have their own full copy, and they can follow along, because the three of you know they're lengthy and kind of dry. So they'll have those with them. But I'll like I said, I generally don't do that chart. All right, so anything else in regards to the instructions?
No, Your Honor.
All right, so my plan would be to have at least a rough draft available for counsel tomorrow. So you at least have that, and depending on the timing and where we go in regards to the actual closings, we'll have the opportunity for you to review those, go over the draft, and then any kind of objections or suggestions you want to make, we'll have a chance to do that. But so you'll have, again, it's a rough draft. That's all I can tell you, and nothing's in stone, but at least give you an idea kind of where I'm coming from.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their three doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. If the parties may need, we can talk about that. But, my old experience, there's been a lot of evidence and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right. Anything else we need to address, you think?
No, Your Honor.
All right. And so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick and then, correct?
Yes.
Yeah, all right. You just kind of looked, I thought, oh. So that would be the thought, and then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses, and if it's not done by Friday, we go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
And Mr. Verino will be here, yes, to set up the Zoom.
So you're not going to trust me to set that up this time?
No.
I think that's a good move.
Or me.
All right. All right. So thank you, everyone. And so we'll be in recess until tomorrow.
Thank you.
Thank you.
Court, all rise. persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Hutchins.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? All right. Again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right. And that is, all right. So can I see counsel sidebar, please?
I'll second, Your Honor, thank you.
Okay.
Your Honor, before the jurors come up.
Sure, hold on.
Court, all rise, please.
Hey, 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 all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor, may I proceed?
Please.
Your Honor, before we go today, we have a continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Hopkins.
Well, good morning, everyone. What I'm going to do is, I was looking for my little cheat sheet about the questions. I thought you could probably say them along with me at this point, but let me ask them just to make sure everybody's able to follow those instructions. So has any member of the jury read, seen, heard, or overheard anything from any source that would affect your ability to be a fair and impartial juror? Next question, is there any other serious matter or concern bearing on your service as a juror? In this case, anybody needs to bring to my attention? Again, as always, thank you for following those instructions. Now, what the schedule for today is that I would expect a longer day, all right, similar to some of the days we had earlier this week. So what we're going to do is we're going to return to the defendant who's going to call their next witness, and that witness is going to be testifying by Zoom or over the monitors that you're going to have here. Just there was an earlier witness, I think, who had also testified that way. And so the delay we had coming in here was just setting that up. It should be all set. They kept me away from all the technology, so I think it should be working pretty well. And then at that point, we'll see what we'll deal with after this witness, and then we'll go on from there. Okay? All right. Thank you. Mr. Reddington?
Judge? I don't know who's got to turn it on. Okay. Thank you.
Could you please raise your right hand, sir? Would you please raise your right hand, sir? Do you solemnly swear that the testimony and the evidence you shall give to the court and the jury in the matter now pending between the Commonwealth and the defendant at the bar shall be the truth, the whole truth, and nothing but the truth, so help you God?
I don't think there's volume.
Would you turn on your volume? You're muted.
Okay, I think I've got it. But it's a little hard for me to hear you on your end. If you could keep your voices up, please.
You want to swear him again?
Yes, please.
Please raise your right hand one more time. You solemnly swear that the testimony and the evidence you shall give to the court and the jury in the matter now pending between the Commonwealth and the defendant at the bar shall be the whole, the truth, the whole truth, and nothing but the truth, so help you God?
He froze.
Yes, I do.
Thank you.
I am able to hear you now.
All right, give it a try.
All right, counsel?
Good morning, doctor. Will you tell us your name in a loud voice so that we can all hear you and spell it for the record?
Philip Resnick, Phillipresnick.
And where do you live, sir? Where do you live? Can you hear me?
You froze up. I can hear you now.
Okay. Where do you live?
I live in the Cleveland, Ohio area.
So this is a delay. Like if I ask a question, there's like a 2 or 3 second delay for your answer. So that's a little difficult, but we'll try to get through it. Can you tell us what you do for work, sir?
Yes, I'm a forensic psychiatrist.
And first off, the reason that you are not appearing here today in court, is that because you have had recent unexpected major surgery regarding an illness, and as of last week, you've now been released from the hospital and you're at home?
I was discharged from the hospital Tuesday night, and there was a recommendation that I not fly for the next few days.
Okay, so you did intend and had tickets to come here and testify, but obviously the court has accommodated us with a Zoom.
Yes.
Okay. Have you worked on this case with Lindsay Clancy at my request, sir?
Yes, I have.
Okay. Can you tell the jurors your educational and professional background, please?
Yes, I have a bachelor's degree in psychology from Case Western Reserve University.
No, it's really low and it's
I graduated high school.
Hold up for a second. We're having technical difficulties.
Can I see counsel here at the side, please? Members of the jury, just like in the old days when you're watching TV, the little sign used to come up and say technical difficulties. That's where we are. So what we're going to do is we're going to take a short break and have people who know more about this than I do to kind of readdress this, all right, to see if we can have a smoother presentation so you're able to follow and listen to the testimony without kind of being broken up and choppy. All right, so I'm going to ask you, well, I hope it's a short break, but that's the goal, is to get this in a manner that is easier for you to hear and absorb this information. So we're going to take a short break, I hope, and we'll see you in a couple of minutes. All right, thank you.
All rise, please. Jurors exiting.
All right, so we'll be in a short recess. We'll kind of see if we get this working again, and we'll be out as soon as that's done.
Court, all rise. This court is back in session. You may be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present excluding the jury.
Are we ready for the jury?
Yes. Fingers crossed.
All right.
I'm leaving.
All rise, please. Jurors entering. Court is back in session. You may be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
Thank you, Madam Clerk. Members of the jury, we're going to give it another go. All right? All right. Go ahead.
Okay, thank you. All right, Doctor, can you hear me?
Yes.
Excellent. Tell us again your name for the record, just and spell the last name.
P-A-I-L-L-I-N-P-R-E-S-N-I-C-K.
All right, and you're going to have to speak a little slower, only because of the microphone. Okay. Tell us your background, sir. I know you're a physician. Tell us your educational background and your work history.
I am a forensic psychiatrist, and I received a bachelor's degree in psychology in 1959 and a medical degree in 1963, both from Case Western Reserve University in Cleveland, Ohio. I then had a 1-month internship in a military hospital in Texas, and then I came back to University Hospitals of Cleveland, where I completed my residency in psychiatry.
And do you
Would you
have...
like me to go further?
I'm sorry, go ahead.
Yeah. Would you like me to
Yeah, you
proceed?
can continue. I interrupted, I apologize.
Yeah. I have remained at Case Western Reserve University as now a full professor, and I've also become interested in forensic psychiatry, that is, that aspect of psychiatry which relates to legal issues such as this case. And I initiated a fellowship in forensic psychiatry in 1979 and directed that for 40 years. I also served as director of the Court Psychiatric Clinic in Cleveland, Ohio for over 40 years.
Doctor, do you have board certifications as well?
Yes, I'm board certified in psychiatry, 1971, and board certified in forensic psychiatry, 1979.
Did you also have added qualifications in forensic psychiatry in 2014, 2024, and recertifications?
Yes.
And have you, without going through them, also had a number of visiting professorships?
Yes, I've had about 14 visiting professorships.
Now, Doctor, this case involves what I guess is referred to as filicide, F-I-L-L-I-C-I-D-E, I believe. Did I spell that right?
Single L.
Single L, okay. Can you tell the jurors what that means?
Now, filicide is a parent killing a child, and it is a relatively infrequent phenomenon that occurs in the United States somewhere between 400 and 500 times a year.
And Doctor, is it fair to say that you have, at least in the country, if not outside the country, the most experience in working on filicide cases?
I believe that's true. I have been personally involved in, I'd estimate about 80 cases where I was asked to evaluate mothers and fathers who had killed their children.
And the question that I have, Doctor, is have you had occasion to work on cases that found themselves in court where you gave testimony either for the government or for the defense?
Yes, I have.
Let me just go through, if I can. So let me just go through so we can cut to the chase. Did you work as an expert on the case of Jeffrey Dahmer?
Yes, I consulted to the prosecution in that case.
Did you also work on the case of what is referred to as the Unabomber, a fellow by the name of Kaczynski?
Yes, I was also a consultant to the government on that case.
Did you also find yourself consulting on the matter of, in Florida, the Commonwealth versus, or the state versus Casey Anthony?
I was a consultant to the defense in that case, but I could not be helpful.
Did you also work on the matter of Andrea Yates?
Yes, I testified for the defense in both of her trials.
Did you also work on the case of what is known as the Aurora movie theater shooting?
Yes, I was a consultant to the prosecutor in that case.
Did you also work on the case involving the Oklahoma City bombing courthouse?
Yes. Again, I was employed by the government in that case.
And in addition to those cases, did you also, in your practice, consult with the defense as well as the prosecution on a number of homicide cases, many of which involve filicide?
Yes, I have.
All right. In the course of this case, sir, did I reach out to you and ask if you would assist me in evaluating Lindsay Clancy?
Yes, you did.
And can you tell the jurors when and for how long you would actually interview, whether it would be Lindsay, whether it would be third-party contacts? Just give us an idea as to how you evaluated her.
Yes, about 4 months after the crime, I did a personal evaluation of Lindsay and her parents to gain information, and I spent 3 hours interviewing her on that date.
And how long did you spend interviewing third-party contacts of her parents?
An hour and 50 minutes.
And this would be in May of 2023?
That's right.
Where did the interview take place?
The interview took place at Duxbury Hospital.
Would that be, is that a hospital facility that's a mental institution in the town or city of Tewksbury?
Tewksbury, yes.
And Lindsay actually came and was living in Duxbury at the time of the incident, is that correct?
That's correct.
All right. So can you describe for us, without getting into any statements that she made to you, tell us about the circumstances. How did she appear to you physically, and how was she able to answer your questions? Just tell us what her appearance was, her mood.
Yes. Well, first of all, at the time, of course, she had suffered major injury and was paralyzed, so that was the setting. So during the examination, she did not have control of the lower part of her body. During the interview, she appeared somewhat matter-of-fact, but at the time she was still grieving. The nurses told me that she was crying daily about the loss of her 3 children, and she was also medicated at that time. She was fully cooperative and gave me a detailed account of her recollections of the critical events.
Did you make an observation of her affect? Did she appear to have what you refer to as a flat affect?
Yes, she did have, or I would call it a blunted affect. That is, her emotions were not, as you would expect. Her feeling tone was muted.
Muted? Is that what you said, muted?
Muted.
Okay.
Yes.
Now, Doctor, in the course of evaluating this case, and again, in the interest of time, would you agree that you had a chance to review a number of items to assist you in your evaluation?
I reviewed extensive records in this case, both records referring to Ms. Clancy's mental illness, how it developed, who her treaters were, and then also I was able to evaluate records after her conduct.
And that would include police reports?
Extensive police reports, yes.
Grand jury testimony?
Yes.
Photographs?
Yes.
Videos?
Yes.
Medical records from healthcare providers such as Dr. Tufts, nurse practitioner Gelada, and McLean Hospital?
Yes.
Were you aware that she had also contacted suicide hotlines and went to a facility in Rhode Island, Women and Infants?
Yes, I reviewed all those records.
So with all of that information, Doctor, that you had access to, did you also have the opportunity to review any records from, let's say, the government's doctors, Dr. Helbrun, Dr. Mack, Dr. Satoff?
Yes, after I prepared my report, I was aware that there were 3 experts employed by the prosecution, and I was able to review their reports in detail also.
Okay. And your report is actually dated, you saw her in 2023, and you prepared your report ultimately after your evaluation in September. Do you know when the government's doctor's reports were available to you? Was that recently?
My recollection is that they did their evaluation about 3 years after the crime, and I had the opportunity to see her 4 months after the crime.
Now, did you also have occasion, sir, to see from Dr. Helbrun, government's doctor, psychiatric testing?
Yes, I did.
Can you tell us, for example, was one of the results on the psychiatric testing a test that he administered for the government called the MMPI, or Minnesota Multiphasic Personality Inventory Test?
That was a psychological test that he administered, yes.
And do you recall from reviewing the records what the results were? Was she faking, was she lying, or was she telling the truth? And
the results showed no evidence of faking.
Hold on.
okay, doctor, I had asked you if you were aware that government's Dr. Halpern had administered the MMPI test and came to a conclusion as to whether or not Lindsay was telling the truth, faking, or exaggerating symptoms. And you relied on that test as a portion of your opinion. Is that right?
Yes, I did.
Can you tell the jurors what the results of that test were, to your knowledge?
The in summary, the results were that Lindsay Clancy had a tendency to minimize and did not have a tendency to exaggerate what she was saying in her own symptoms.
Did it also indicate that she was not, I think the terminology is faking or lying in her answers, but in fact was being truthful as best she could be?
Yes, although the test is a little more specific about symptoms rather than lying or not lying, but it did not suggest any evidence of faking symptoms.
Okay, and I'm sorry, that broke up. It did not suggest any evidence of what?
No evidence of faking psychiatric symptoms.
And then finally, one of the scales in that test is referred to as the K, I think from the books, the K scale or the lie scale. Is that correct?
Yes, that was not elevated.
Not elevated. Okay. Now, doctor, in your experience, do you have any particular subspecialty or interest in the concept of people that are malingering or faking in the forensic world? In other words, if it's a criminal case, if it's a workman's comp case where somebody's pretending their back hurts, things of that nature, have you focused on that as a subspecialty or interest in your career?
That has been a major interest. I've actually written 46 articles or book chapters in this area. The first was 1984, and over the course of that, of course, new research comes out. So when I write a new edition of a book chapter, it would incorporate new material. So even though the chapter may go through 5 editions in a particular book, they're up to date, and the ones which were written earlier would no longer be the best basis for forming an opinion.
Now, for example, when you reviewed Dr. Helbrun's report for the government, did he refer to your articles?
He did refer to my research, yes.
And was that updated research or was it old research that he referenced?
He referenced older research.
So can you tell us, Doctor, when you consider let me start over again. When you reviewed Lindsay's medical records, you also reviewed the psychopharmacology, in other words, the medications that Dr. Tufts and Gelada and all of these other doctors had prescribed to her during that period of time?
Yes, I did.
And have in mind your interview, the time that you spent with her directly reviewing all of the documents, all of the medical records, everything that we've talked about. And you're also aware from her, not specifically what she said to you, but you're aware of the circumstances from her recollection as to the killings that she told you. Is that correct?
Yes, as well as the journal she kept and other evidence of her thinking and symptoms as the time approached for the crime on January 24th, 2023.
Okay, and you were also aware of her access to her cell phone, doing Google searches and looking up medications during that period of October, November, December, and January. You're aware of that, correct?
Yes.
Okay, and can you tell the jurors, in your opinion, sir, with your years of experience in the issue of filicide, working for just the government on a number of cases and the defense, and your evaluation of Lindsay, can you tell this jury your opinion as to whether or not at the time of the killings that she was suffering from a disease or defect that impaired her ability to substantially appreciate and or conform her conduct to the requirements of the law?
Well, sure. Let me begin with the issue of whether she had a mental disease or a defect. Ms. Clancy had a severe depression. There is a book called the DSM, or Diagnostic Manual, prepared by the American Psychiatric Association, which lists criteria for various diseases. So in the diagnostic manual, for example, one needs to have 5 out of 9 symptoms to make a diagnosis of major depression. And Ms. Clancy, as she approached the date of the crime, actually had 7 of the 9 symptoms and was severely depressed. So that in addition to that, she had some earlier evidence of what's called a mild mania, and that fits together in what's called bipolar 2. So in other words, it's a type of bipolar illness where there is more frank depression, severe depression, but the manic aspects are not as severe. So my final diagnosis of her was called bipolar 2 with a severe depression on January 24, 2023. And from reading the reports of all the experts that will be testifying, no one failed to diagnose a major mental disease on the day of the crime.
Now, doctor, in the course of that diagnosis, have you considered the concept of postpartum depression and or postpartum psychosis?
Yes.
And can you tell the jurors how that...
First of all,
I'm sorry. Can you tell the jurors how that factors into your diagnosis and opinion?
Yes. Ms. Clancy had a history of anxiety and difficulty with each of her children. It was minor with her first child, more significant with her second child, and on the occasion of Callan's birth, things went well for the first 3 months, But then Ms. Clancy became very anxious and depressed, and it took quite a toll on her. And I believe the jury has heard from various treaters, such as Dr. Tufts and Nurse Delata and others, and her own anguish about how depressed she was, where she actually felt she couldn't function, her brain was damaged, she would never be the same. So she definitely met the definition of a major depression as well as this bipolar phenomenon. Now, with respect to the postpartum aspect, since Ms. Clancy's symptoms began within 3 months of Callan's birth, that would be considered a postpartum onset. Then, of course, she had considerable difficulty over the next 5 months, and at the time of the crime itself, on January 24, 2023, Ms. Clancy was frankly psychotic. So in that sense, she had a postpartum psychosis. It's actually not frequent to have a postpartum psychosis 8 months after a birth, but it does occasionally occur. And so what I can say is whether it is the classic postpartum psychosis or not, with the postpartum onset and frank psychosis on the day of the killing, I would label that a postpartum psychosis in the sense that it was a postpartum onset and she was clearly psychotic on that day.
And Doctor, when a person is psychotic or involved in having a psychosis, in your opinion, are they able to appear normal, quote unquote, communicate